All right. Good afternoon, everybody. It's been like probably 3 months or longer since I've been live. Okay. So how we gonna do this is I don't have a call-in number today, so you just post your questions into the chat, and then I'll answer your questions like that. But there is there's probably gonna be some cases, that I want to read and just go over and show you. Um, just to kind of give y'all an idea of what's really going on. Well, before I begin, I need to know on a scale of 1 to 10, how good can y'all hear me on a scale of 1 to 10? So comment the number below on a scale of 1 to 10, how good you can hear me, and I'll come back and check. I'm trying to find a case that I wanted to read y'all to show y'all where they're getting, where the legislature is getting a lot of their so-called laws from. So what they do is when they find something established by the judiciary branch, if that makes sense, they will bring it over into their territories and they will codify it. They'll put it into their codes, into their legislation. They will adopt it over for their dependents or their subjects or their things within their territory, such as an incorporated city, county, or town, for them to follow, for their administrative agencies, because a city is an administrative agency. A county is an administrative agency. A town is an administrative agency to the extent that they've all been incorporated. That's essentially what's going on. I'm going to see if I can find this case. Got that. I think I think I'm gonna read that to y'all too. I'm still trying to find something. It might not be in this case. Let me go back and check the chat. I wish I could find that case. We'll see if I can find it. It's on my computer. I gotta see if I can. I gotta see if I can find it. Okay, good. Everybody can hear me. Good. Okay. Let me I want to point. Let me point something out to y'all in this case. I'm pretty sure I got a good idea that y'all already know this, but I'm gonna go back over it because this goes back to the case of Collins versus what was it? Collins versus City of Chicago. And in Collins versus the City of Chicago, what they essentially told you was the driver's license. It's not really a license to use the streets because everyone has a right to use the streets. That includes corporations as well. You know what I'm saying? So corporations have a right to use the public highways to the extent just as you would, if that makes sense, privately, as long as they are using it for their own business, or if they're using it then where is that? Let me go and find this case. Let me show it to you. Let me see if I can show you what I'm talking about. It's gonna be in here. I saved it in here. I got a lot of cases in here, and these are a lot of old cases, but they are very good cases. And I wish I can find the one. I should have wrote it down. The one that I really wanted to show y'all. That's what I should have did. Let's go back to Collins. Is this it? I think this is it, but this ain't the case that I wanted to show y'all. So, this case right here. So let me go back here and let me where is it at? Right here. Trying to show y'all like what's going on for real in regards to the right to travel. Let me go back and check the chat right quick. All right, good. All right, y'all hit that thumbs up for me. Hit that like button if y'all don't mind. All right, so let me go back here. So what is this given? Okay, in Green versus San Antonio. So this is this appears to be a Texas. This appears to be a court of civil appeals in Texas, or probably criminal appeals in Texas. And this is essentially what they held. So the streets and highways belong to the public. They are built and maintained at public expense for the use of the general public in the ordinary and customary manner. The state and city, as an arm of the state, has absolute control of the streets in the interest of the public. No private individual or corporation has a right to use the streets, to the use of the streets in the prosecution of the business of a common carrier for private gain without the consent of the state. So generally speaking, what they're talking about right there is generally speaking, that's only what they can regulate. Now they can regulate other shit too, but they can't require you to have a license. Is essentially what they're saying, because you have a right to use the streets. What you do not have a right to do is use it for private gain. That's what they're regulating. And the reason they're doing that is because of equity. That's why they're doing that. It's all because of equity. If you go back to this case right here, it clearly tells you. It clearly tells you that when it says right. Let me go back. When it says, damn it, come on. When it says right here, right here, the city may also regulate certain occupations. What they are regulating within their territory are occupations. So let's say if you want to come out of private practice outside the corporate territorial jurisdiction of municipal corporations, and if you wanted to go within it, and you want it to be a dentist or something like that, they're going to require you to have a license to be over there doing business. That's an occupation license to be over there doing business within that municipality, within that territory. That's an occupation license. The reason why they're going to tax you for it is because essentially, if they wait too long and they don't tax you for it, then they could be collaterally stopped from bringing a claim against you to prosecuting you for over there engaging in that so-called practice without a license. They could be collaterally stopped from doing that. That's one reason why they're doing it. So the city may also regulate certain occupations, such as a hackman, which is that's an old term for a taxi driver. A drayman, I think I showed y'all what a drayman was, but if I didn't, let me go and show you again. We are on, and y'all can go ahead. If y'all have any questions, just post them into the chat, and I'll get to them when I can. What was it? It's Google. Let me show y'all what a drayman is. Drayman right here. All right. So a drayman was historically the driver. Driving is an occupation, y'all. That's why they're calling it a driver's license, like a nursing license, a dental license, a so-called license to practice law. I'm of the opinion that, and I could be wrong, but I'm going to say I'm about 98 to 99% sure that I'm right about this. If you're over there within their territory, engaged in some form of business for profit, they're going to tax you for it. In other words, they're going to require that you have a license for it. Because if they don't, they could be collaterally stopped from requiring you to have a license for it if they wait too long. Equity is not going to allow them to do that. A drayman was historically the driver of a dray. What is a dray? So this is a dray right here. A dray, a low flatbed wagon without sides, pulled generally by horses or mules that were used to transport all kinds of goods. Are y'all paying attention to the language there? That's what a drayman is. The word drayman is used in U.S. ports as the over-the-road highway truck drivers who deliver containers to and from the port. This is one form of what a drayman is. So yeah, they can regulate that because you can't engage in private gain. You can't do that because the reason why you can't do that is because you don't own the public highways. It's not yours. It belongs to the general public, so they have to tax you for it. And if they don't, they could be collaterally stopped from taxing you for it. So let's go back here. So that's a drayman. An expressman would be somebody like UPS, FedEx, what else? Was it Courier Express or something like that? Let me go back to it. Expressman. But they're getting paid for it. An expressman is a person who is employed by an express company to pack, manage, and deliver cargo. In the 19th and early 20th centuries, expressmen were responsible for the safety delivery of gold and currency by railroad. Yada, yada, yada. So here's where where it applies to truck drivers at, because when they say and the like, they mean anything similar to a hackman, drayman, or expressman. That's what they mean, and the like. That's what they can regulate. For such regulation is of a police character, having reference to the general welfare as a means of preventing improper exactions and extortions, and for the same reasons a license may be exacted for such vehicles used in the transportation of goods and merchandise. I want y'all to pay attention to these commercial terms. These are commercial terms that they're using. And as a means of preventing improper exactions and extortions, and for the same reason, a tax may be exacted for vehicles used in the transportation of goods and merchandise or of passengers for other purposes, or for other purposes of traffic. This is what they're talking about. But such license is an occupation license. They're telling you exactly what today's driver's license is. Despite the fact that they're calling it a driver's license, it's really an occupation license because driving is an occupation. That's what they're presuming. The reason for that is you have state plates on your car, so-called your car anyway, but you don't even own the car. You have a certificate of title. So they took the legal title to it. Nobody knows what the hell it is. The state has it. So the state is essentially acting as if they're the owner, and they're giving you a driver's license. This makes so much sense to me now. It really makes so much sense to me. Let me go back to the chat and see if any questions are in here. But this just really makes so much sense to me as to what's going on. Let me see. Trying to see if I can decipher this in another way. Go back to it. Such license is an occupation license and not one for the use of the streets. If they could, let me go back up and show y'all something. This is what this case essentially said. So what they essentially said was if the city could outright, or if the city had the absolute right to require anyone using any mode of travel on the public streets, then they can essentially tax the pedestrian. In other words, they can require pedestrians have a license just to walk down the street. But they can't do that. And that's exactly what they said in this case. It says, let me see, I'm going to start with, I'm going to read the whole thing all the way down to right here at the word the same. I'm going to start right there. This case is essentially telling y'all what they did, man. The streets and alleys of a city are held in trust, because they are trustees, by the municipality for the use of the public for purposes of travel thereon, and as a means of access to and egress from buildings abutting thereon or lots adjacent thereto. The right to travel on and along the streets of a city belongs to the general public and does not belong to its denizens alone. The right to travel being in the general public everywhere, all persons have a right to pass along and use the streets and alleys of a city in all their parts, the full width and length thereof. The municipality, which is a mere trustee. So when they say municipality, so what's going on is, so people a long time ago with that, and let's use the city of Chicago. So the people a long time ago in the city of Chicago who actually owned the land then, that was private property. So what they did was when they formed a corporation called the City of Chicago, it was no longer private property. It became public property. And since it became public property or quasi-public property, it became subject to public law, such as the Constitution and statutes and codes or whatever. Okay, when they formed that municipal corporation, the legislature required that they designated where their corporate territorial jurisdiction would begin and where their corporate territorial jurisdiction would end. And anything within that corporate territory jurisdiction, statutes have the force and effect of law. And anything outside of that, statutes do not have essentially no authority over that. You can't enforce the statutes over there, generally speaking, because if that essentially that constitutes a taking, because you are enforcing you're enforcing public policy or public so-called laws on private property that is outside the corporate territorial jurisdiction of the legislature, because you have a right to be subject to statutes and codes, and you have a right not to be subject to statutes and codes. Being, let me see, how do I word this in another way? You have a right, like if you want to receive food stamps and welfare and government assistance because you just can't take care of yourself, you have a right to apply for that if that's what you want. And if you don't want to, as you apply for that, then what you're doing is you are either expressly or you are implicitly, essentially bartering away your private rights, or limiting or restricting your private rights when you do that. And if you don't want to do that, you don't want to accept anything from them, there's essentially they really can't do nothing to you. They're not supposed to be doing this. I'm telling you what I know, not what I think. They're not supposed to be doing this. But that's what they're doing because they don't want to tell people what the hell is going on. All right. Oh, let me check the chat right quick. All right. Okay. Where are we at? Right here. Okay. The municipality or the corporation, which is a mere trustee of the public and holds the streets and alleys in trust for that public, cannot deny the right of the public to use the streets and alleys. It cannot assume an exclusive ownership. This is what they're doing, y'all. And deny the rights of the beneficiary, would be you, under their trust, and arrogate to itself a power greater than that of a mere trustee. And that is exactly what the fuck they are doing. That's what they're doing. And prevent the use of the streets and alleys by individual members of the public. Why does it keep doing that? I'm not sure why. Where is it at? Right here. Okay, we down here. The right of the public to use the streets is the right to use them for purposes of travel in the recognized methods in which the public highways of the state are used. They say right here, any method of travel may be adopted by the individual members of the public. So when they say any method, walking down the street is traveling. Riding a bicycle down the street is traveling. Riding in a horse and carriage down the street is traveling. Riding in an automobile down the street, so-called motor vehicle down the street, is traveling. Riding in an 18-wheeler down the street is fucking traveling. All of that is traveling. Any method of travel may be adopted by individual members of the public, which is an ordinary method of locomotion, or even an extraordinary method. When they say extraordinary method, they're talking about people who are using it as a place of business, because they essentially have a right to use the streets. They don't have a right to use it for private gain. They don't have a right to do that. Or even an extraordinary method. If it is not of itself calculated to prevent a reasonably safe use of the streets by others. So you have to be safe. I want y'all to notice that they're not citing any statutes in here at all. But what they're telling you is, yeah, you sovereign, but you can't do what you want to do. Okay. Now we won't, essentially what they're saying is, okay, the government, if that makes sense, will not come into the private and fuck with you unless you infringe on somebody else's rights. You have a duty to everybody else, even though you're sovereign. You have a duty to everybody else to act reasonably, not recklessly, in disregard for the safety of others. Essentially, if that makes sense, that's essentially what they're saying. Okay, you have to be careful. You have to think about stuff before you do it. I don't care if there's a statute requiring you to do it or not. You still have to do it. Equity is going to require you to do that, and so is common law. I'm gonna read this one more time. Where is that? The hell is that? Any method of travel may be adopted by individual members of the public, which is an ordinary method of locomotion, or even an extraordinary method, if it is not of itself calculated to prevent a reasonably safe use of the streets by others. Pay attention to this, y'all. If a right exists in a city council to impose a tax on every person using wheeled vehicles thereon, it may in like manner impose such tax for such use of the streets in every other manner of locomotion or travel, and reach the man on horseback or the pedestrian walking along the same. That's what they're saying. They figured this case is probably over 125 years old, and they figured they just thought way ahead. Way ahead. Essentially, that's what they're doing. Now, let me tell y'all something. And I want y'all to think. Use your heads. If the city cannot tax you for walking down the streets, this case right here proves that they cannot require that you have a license simply to walk down the streets. Then what makes you think that they can tax you for exercising your right, or in other words, any method of travel, whether it be by horseback or car? What makes you think that they can tax you for that? Because they can't. I think when I read this case went over a lot of people's heads. It went over a lot of people's heads. Let's see. Gary says, without an injury, they can't do anything. That's why you can buy insurance money to protect your private property. Yep. A lot of people don't know that, but you don't have to get insurance on your car. You can get a bond. That's actually in a code in Alabama. You can actually get a bond to cover you, and that would suffice and avoid you having a traffic ticket for no insurance, if that makes sense. You can really get a bond for that. I've seen it in the statutes. Let's see. Okay, somebody. I'm sorry, y'all. Somebody they sending me messages right now. Okay. So let me go back. What's back? Okay, I want to show y'all this right here too. I'm pretty sure y'all already know this, but I'm gonna go over it again. Anything which cannot be enjoyed without legal authority would be a mere privilege, which is generally evidenced by a license. The use of the public streets of a city is not a privilege, but a right. This case, there are cases that are older than this case citing this. This is where they're getting all of their stuff from, y'all. So what they do is they find out what they like and what they don't like. And anything that they like, they codify it. They adopt it into their legislation over into their territories for their executive administrators to enforce. For all of their administrative agencies, these administrative agencies called the city of, town of, and county of, or the school board, or the DMV, Child Protective Services, or the DOT, all of these are administrative agencies. This is what they call the administrative state. So in other words, essentially what that means is you're dealing with the so-called state in an administrative capacity. Essentially, what you're dealing with is the legislative branch of government, essentially what you're dealing with, because the legislature is creating all of these administrative agencies. That's essentially what it is. That's who you're dealing with. Let me go back. Hold on, y'all. Okay, conditions prescribed, the state or municipality, a case may be thus the streets as the public business to maintain. I'm trying to, where is that? Is it in here? It might be up here. Is it in here? The run was in. Okay, that's ex parte Dickey. It gotta be, it might be up here. Okay, I think it's going to be up here. Another thing that I want to let y'all know. I'm gonna try to read this to y'all, and hopefully y'all will get it. If not, I'll see if I can explain it to you. Right here, it says, it is well established that a business affected with a public use may be regulated by the state. The general principle applying to this class of cases is well stated in Tideman on Limitations, section 93, and quoted with approval in Kentucky. In Kentucky, this is a Kentucky Supreme Court case. But anyway, essentially what that case held was, whenever the business is itself a privilege or franchise not enjoyed by all alike, or the business is materially benefited by the gift by the state of some special privileges to be enjoyed in connection with it, the business ceases to be strictly private and becomes a quasi-public business. This is how, what they're doing is they're mixing the, long story short, there are corporations forming, they're corporations masquerading as government. That is essentially what all of they are. And to that extent may be subjected to police regulations. So like when the people, let's say the people in Chicago, when they formed a municipal corporation, okay, even though it was even though they were private, when they became public, or when they got when they were invested with a privilege or a franchise, all right, let me see, how do I word this? A privilege or a franchise, the business materially benefited, they materially benefited by the gift of the state of some special privileges. So when they got that charter, that constitution, even though they don't call it a constitution, it's a charter, it's really a constitution. When they got that, they ceased to become strictly private, and they became a quasi-public business. That's why they can't violate the so-called constitution. I hope y'all are getting this. I hope y'all are understanding this stuff, because they didn't just do this in Chicago or Illinois. Illinois. They did not just do this in just one random state. They did this in like 99% of this country. They did this everywhere. A lot of people do not. When I try to tell people this, it's just confusing to them. But you are in a fucking territory. That is what you're in. You're in a territory. They're not, well, they do call it a territory, but I'm going to see if I can find this and try to decipher it for y'all. Let me read these comments. That's why they force you to pay child support, because they claim a divorce is an injury. That's a good point of view. Never heard of that though before. But you have never been found to cause the injury. That why they need the mother to say she been hit. That I mean, I can kind of see that. I mean, it's starting to make sense a little. There was a British lady that had a video out about having a security agreement instead of insurance. I think she did an SPC type process beforehand, though she didn't get specific on that part. Almost. Let me see if I can find. I'm gonna see if I can find it in Alabama. Motor vehicle insurance or bond, Alabama code. Let's see if I can find it. Is it this? It might be this one right here. This is the motor vehicle code right here, so it's probably this right here. So let me go here. Is that it? I think this is it right here. No person shall mandatory. Yeah, this is it right here. This is the title and code right here. All right, okay, right here. I want y'all to pay attention to something, man. I don't know how many times that I have to keep telling people this. You're in a territory, man. Let me show y'all what I'm talking about. First, let me show y'all this. All legislation is territorial and does not apply. All right, let's try it like that. I'm going to have to broaden my search a little bit because I want y'all to see this. So let me take it off New York and broaden my search. Right here. It is right here. All legislation is prima facie territorial, and it does not operate beyond the limits of the jurisdiction in which it is enacted. That's one, and this is an Alabama. I'm not in Alabama. This is a United States Supreme Court case. This is out of the District Court of Minnesota. This is the Third Circuit. Let's see. It is well established that all congressional legislation is presumed to apply only within the territorial jurisdiction of the United States. Legislation is meant only. Is meant to apply only within the territorial jurisdiction of the United States. So let me show you. A county is a territory of the state. So right here. It is fundamental that the county is a subdivision of the state. Political subdivisions or territories created out of the territory of the state. A county is a local subdivision of a state or territory. A county, strictly speaking, is a body politic. It is an entity, a subdivision of a state that includes the population defined in a geographical area, blah, blah, blah. All right. A city is a territory. Where is it at? A city is a political subdivision of a state. A political subdivision is a territory. It is a public corporate authority, and no more than the territory or state then is a sue. What is this? And respondent is not the territory or the state of Alaska. I have to call them back. Trying to see if I can narrow this down. It is true that the legislative power to incorporate a home rule city is, by constitutional provision, delegated to the inhabitants of the territory affected. Nevertheless, a city is so incorporated as a political subdivision of the state for governmental purposes. For governmental purposes or for public purposes. For public purposes. A city is a municipal corporation created by the legislature. It is a territory. It's an administrative agency. A territory is defined as a state, city, or geographic area containing 6 million people. Hold on, y'all. I got to take this phone call. Give me a second. Hello. You want to live right now? All right. Sorry about that, y'all. Let me get me some water. I'm really just trying to get people to understand this. Okay, I think I got my point across. You're in a territory, so now let's go back to this. All legislation is territorial, whether it be over a geographical area, a person, a thing, that was birthed within, or I'm saying within that geographical area, if that makes sense. So, right here, no person, they just keep using person. No person shall operate, register, or maintain registration of, and no owner shall permit another person to operate, register, or maintain registration of a motor vehicle designed to be used on the public highways unless motor vehicle is covered by a liability insurance policy, a commercial automobile liability policy, motor vehicle liability bond, or or a deposit of cash. Same thing. It's a security. They want some sort of security. That's what they want. And I'm not totally against that, because obviously you want, like, if somebody hits your car or something, you want them to fix it. You know what I'm saying? You want them to make you whole. You know what I'm saying? So I get that. What is this, number 2? The motor vehicle liability bond shall be in the amount of not less than the minimum amounts of liability coverage for bodily injury or death and for the destruction of property under subsection C. But I want y'all to pay attention. These are statutes. This is in a territory. All legislation is territorial. This is you're in an administrative agency. The city is an administrative agency. The municipal court is an administrative agency. The damn city council is an administrative agency. The mayor's office is an administrative agency. Everything in the city is an administrative agency. The fire department is an administrative agency. The sheriff department is an administrative agency. The police department is an administrative agency. Child Protective Services is an administrative agency. And they are enforcing statutes. So what I'm trying to get y'all to understand is every single one of them is an administrative agency, and all of them are members of the executive branch of government. I don't give a fuck if they call it a court. It's not a court. Let me see, business license. I'm gonna get back to that in a minute. The U.S. exists as a continuing series of contracts. You are presumed to be under contract by written or verbal agreement, license, or engaged in an activity the U.S. has control over, commerce. That's the only thing that they can regulate. But the problem with this is It's when you start accepting benefits and privileges from these people, and when you in that territory, that's the problem. And a lot of people don't know this about, like, when you live in a so-called city, it's just a territory. That's why they're enforcing statutes and codes over there. You're in a territory. Any of those activities at least create a presumption that you are subject to the regulations and taxations. I agree with that because, one, you're living in a territory. A territory is a dependent. They get all of their funding from the government. They're dependencies. So if you're over there in a territory, and this territory is a dependency, you can reasonably conclude, or they can reasonably conclude, although they may be wrong, because you can be wrong by making reasonable conclusions, but they can reasonably conclude that you are a damn dependent, or that you are a U.S. citizen engaged in business. You have Federal Reserve notes in your pocket. You know, you have a bank account. You have an address over here. All of this stuff exists within this territory. That's what's going on. Y'all hit that like button for me if y'all don't mind. Let me see. The motor vehicle liability bond shall be in the amount of not less than the minimum amounts of liability coverage for bodily injury or death and for the destruction of property under subsection C of section 3276. The bond shall be conditioned on the payment of the amount of any judgment rendered against the principal in the bond or any person responsible for the operation of the principal's motor vehicle with his or her express or implied consent arising from injury, death, or damage sustained through the use, operation, maintenance, or control of the motor vehicle within the state of Alabama. Within. They're talking about within their territories. They can't. If it's not within the territory, it does not. It is without the state of Alabama. Notice that this S is capitalized. That S should not be capitalized. It shouldn't be capitalized. The only thing that should be capitalized is this A right here. That's it. But yeah, you can get a bond, for insurance purposes. They might allow you to do that, in some other states. I agree with that, SG. To be honest with you, I've already said this once, but even though I live in a municipality, but you should not, I repeat, you should not be living within a territory unless it is for business purposes. That is the only reason you should be there, is for business purposes. Everything here is a business. The city is a business. The so-called courts are a business. The damn the Child Protective Service. All of these people have EINs and DUNS numbers. All of these so-called businesses, they have EINs and DUNS numbers. That's why you have all of these restaurants here. That's why a lot of property is owned here, like houses. What is it? Real estate. I'm trying to see what else. Taxi drivers, law firms, nurses, everything like that. And all of them, generally speaking, have an occupation license. They're being taxed for coming over here to do business. Because if they don't, then eventually, if the city waits too long, they could be collaterally stopped from enforcing their rights, just like you can. That's why you don't wait and you don't sleep on your rights. You don't do that. I wish I could find that case and show it to y'all. I really do. Let's see. Let them know statutes or contracts. I agree with that. They don't have to be called contracts, but I agree with that. I see why they calling them contracts now, because when you apply for a court, for example, if statutes were really laws, then why would the legislature need your permission to exercise corporate territorial jurisdiction over your land before they start enforcing their statutes over private property? Let me see if I can find that. What's the name of that damn case? It was a city in Alabama. I think it was town of Centennial, where they were applying they were applying for a corporate charter. They were incorporating a city, a business for municipal purposes. So they were coming out of the private into the public, and they were voluntarily doing that. Yeah, more like corporate bylaws. Yeah, I agree with that. That's what they are. Corporate bylaws. And what they are doing is they are enforcing their corporate bylaws on you. They're deeming you a corporator, a subject or thing, something like that within their territory. That's what they're deeming you to be. And when you come in and rebut this presumption, they want to call you crazy and call you a sovereign citizen and just ignore you and ask you, do you need a mental evaluation and all this shit? When they're not even qualified to do that because they're not even expert witnesses. But that's what they do. I'm gonna see if I can find that case for y'all, man. It was about damn. I wish I could find that case. Damn, I wish I could find that case. Including the exercise, being without subject. Companies have no business in the hearing right. That's export dicky. Y'all already know that. No except upon the terms and conditions prescribed by the state or municipality, as the case may be. Blah blah blah. The use of the streets as a place of business or as a means of instruction business is a mere privilege and not a matter of natural right. I'm clear in the prosecution of the business is right, but a mere privilege. Yeah, we already know this shit. We already know this. From the street prosecution of various, notwithstanding the right traveling. I can't really find that case, man. I wish I could find that case. Man, I wish I could find that case, y'all. But anyway, y'all go ahead and post some of y'all questions into the chat. I'm gonna do my best to answer some questions. I had somebody. Let me go and see if I can go on my YouTube channel. I think he said he was out of time or something to file his lawsuit, and something about statutes of limitations. And I was trying to answer his question. I don't know if it was a man or a woman. So if I get your gender wrong, I do apologize because it's not on purpose. I think it's down here. Is it right here? Let's see. Yeah, right here. Okay. He says unfortunately my opportunity has passed statute of limitations. No standing moot. OIG, I'm not sure what that means. Report attorneys lied about communicating with me, and the DEA was late reporting poisoning. Commissioner this has control. Commissioner, this has, I'm not sure how they're wording that, but control over every aspect of my life. Commissioner, the Postal Service admin, and government kept all my. I'm not really sure what they're trying to say. But anyway, look, if the delay in you filing your lawsuit is through no fault of your own, then there's a chance that you could still file your lawsuit. If the delay is through no fault of your own, for example, if the defendants do something that matter of fact, I got a better way to show you. I'm gonna show you in I think it's in Henry Gibson's equity proceedings, and I'm gonna show y'all exactly what I'm talking about. Henry, right here. What is it? I think it's 71. Let me see. Equity follows the law. I think it may be this one right here. Yeah, it's this one right here. So section 51 in the treaties and Henry Gibson's treatise on equity. All right, I'm gonna read this to you. No one can take advantage of his own wrong. So what I'm saying is, if it is not your fault, let's say it's the people's fault who you're trying to sue, that the statutes of limitations has ran out. If it's their fault and not yours, you still can sue them if it's their fault. In vain should he seek the aid of equity who has violated equity, which means you cannot violate equity and at the same time seek equity. You can't do that. Such a person in the sight of a court of chancery has dirty hands. You have unclean hands because you have violated equity. If a person could take advantage of his own wrong, it would be a direct bribe to commit the wrong. In other words, it would be like a reward to just do the wrong in the first place. This maxim applies where a trustee buys property in his own name with trust funds, like the city. The city can't do that. Public servants, they can't do that. Where a trustee makes a profit by means of his trust, where a fiduciary obtains a good bargain by means of his position of confidence or influence, where a tenant or trespasser cuts down timber, where a party stands by and does not object to his own goods being sold as another's, where the true owner allows a bona fide purchaser to make improvements, and where a defendant fraudulently conceals the cause of action from the plaintiff. Pay attention to this, because this particular comment is for you. And where a defendant fraudulently conceals the cause of action from the complainant and then pleads the statutes of limitations as a defense to stop you from bringing your lawsuit against them. They can't do that. They can't do that. Nobody can take advantage of their own wrong. In no case. I don't care if it's common law, admiralty, or maritime. You cannot take advantage of your own wrong and then seek equity. It doesn't work like that. That's not how equity works. Yeah, SG, that's right. There are some exceptions to statutes of limitations. The Chicago case is pivotal. You can file past the date if you discovered the violation late. Yeah and no. You can also, let's say, what is the name of that case? I think it's in my email, but there was somebody, he was, I think it happened like the 80s or something like that. And then after, let me see if I can just find the case, because I'm just stumbling all over my words, unless I can do that. So we're gonna go to Google, and I think, who did I send that to? I think I sent it to somebody who I was helping. Matter of fact, it is JD. Is it that one? Let me just go back here and do it like this. And I'm gonna see if I can show y'all what I'm talking about. Now, it's a long case and it's very old, but it's a long case. I'll never find it like this. Damn, what's the name of that case? Is it Wilson? Let me see. Will. That's 8. There it is, right there. Right here. All right. Now, this is a very long case. I'm not going to read all this case, but this was decided in 2023. This is the principle. All right. Let's get to the facts. Where are we at? Okay, right here. On February 9th, 1982, Chicago police officers, and if you're in Chicago, if you're old enough to remember this stuff, you might remember this stuff. Chicago police officer William Fahey and Richard O'Brien were shot and killed during a traffic stop. The murderers led the largest manhunt in the city of Chicago. 5 days later, plaintiff Jackie Wilson and his brother Andrew Wilson were arrested by the Chicago Police Department for their murders, at which they were allegedly tortured by a Chicago police officer into confessing to the murders. Wilson and Andrew were tried for the murders and found guilty. Wilson was sentenced to life imprisonment. The Illinois appellate court reversed Wilson's conviction and granted him a new trial. Wilson was retried and convicted for the murder of O'Brien, but acquitted for the murder of Fahey. Wilson's conviction was affirmed by the Illinois appellate court. Wilson subsequently filed a complaint with the Illinois Torture Inquiry and Relief Commission, alleging that his statements were involuntary and that they were the product of torture, by Chicago police officers. In 2018, the Circuit Court of Cook County ruled that Wilson's confession was tortured from him and granted him a new trial at which the confession was barred. 2 years later, the office of the special prosecutor began Wilson's third trial, relying on manufactured and false evidence. The special prosecutor, however, mid-trial moved to dismiss all charges with prejudice. Wilson then filed a spiraling 10-count complaint against 17 defendants who include Chicago police officers, former Cook County state attorneys, former City of Chicago officials, and the City of Chicago, asserting 42 Section 1983 claims and supplemental state law claims. I'm trying to see, when did he sue them? When was he exonerated? When was he got a judgment in his favor? It should say it in here. Let me see. Where is it at? I guess I got to go down some more. They're going to tell you that that it's timely. He still was successfully able to sue them, if I'm not mistaken. And this happened over 40 years ago. Where is it at? Let's get to the statute of limitations. That's what they're going to tell you at. Right here, okay. Let's see, timeliness of Section 1983 claims. Okay, it is undisputed that Section 1983 claims have a 2-year statute of limitations in Chicago. A Section 1983 claim borrows the statute of limitations for analogous personal injury claims in the form state. In Illinois, that period is 2 years. State law determines the length of the statute of limitations period. Federal law determines when such a claim accrues. So I'm going to stop right there. Let me tell y'all this. You can only sue somebody when all of the elements in support of your cause of action have accrued. If all of the elements are not there, you cannot sue them. You have to wait. A Section 1983 claim accrues when the constitutional violation is complete and the plaintiff has a present cause of action, that is, when plaintiff can file suit and obtain relief. A Section 1983 cause of action for damages attributable to an unconstitutional conviction or sentence that necessarily implies the invalidity of the conviction or sentence does not accrue until the conviction or sentence has been invalidated. So whenever his sentence or conviction was invalidated, that's when the statute of limitations began to run. Requirements prevent a convicted criminal from collaterally attacking his conviction with a civil suit. Defendants contend Wilson's Section 1983 claims are time barred because he did not file his suit within 2 years after 2018 when his 1989 conviction was vacated. He was released on bond, and all the evidence regarding his cursed confession was ruled suppressed and inadmissible at any new trial. Wilson retorts that under Heck deferral accrual rule, his Section 1983 claim did not accrue until his criminal proceedings ended for good in October of 2020. So he's arguing that his cause of action was present on a different date as to what the defendants are arguing. So they're arguing that he's out of time. They're arguing that it accrued on June 2018, and he's arguing that that's not true. It accrued on October of 2020. If they accrue on October 2020, all of his claims are timely. Now I want y'all to pay attention because this happened in the 80s. This is like over 40 years ago. And they're saying that his claim is not time barred. Let me see. What is this? The Chicago company case is pivotal because it distinguishes between prohibition and regulation of the public roads. Yeah. There are some exceptions to statute of limitations. Yeah. So let me get back to that. Y'all hit that like button for me if y'all don't mind. Where is it at? Is it? Where's the damn? Was it up here somewhere? Oh, it's right here. Okay. All Section 1983 counts relating to coerced confessions. Most of Wilson's Section 1983 claims brought under the 4th, 5th, and 14th Amendments arise out of defendants' alleged coercion of a false confession from Wilson, the prosecution's use of that confession to obtain and convict Wilson in his Section 1983, in his 1983 and 1989 trials, and the continuation of his conviction due to the suppression of evidence of Wilson and others' torture at the hands of Burge and his associates. Similarly, Wilson's Monell allegations against the city are centered on the alleged pattern and practice of torture and abuse under Burge to coerce confessions and the alleged cover-up and ratification of that misconduct. I'm trying to get to the ruling that where they state that his claims are timely. Give me a second. I'm trying to find it for y'all. Timely. Let's go up here. Less than 2 years before he filed a lawsuit. Accordingly, even if the court were to follow the Ninth Circuit's pre-McDonough holding in Jackson and find that Wilson statement based on 20 offense, right there you can see what they're saying his claim is timely. They're saying he filed it within time. That's one of them, but I'm trying to see what time is. This conviction was not reversed until 2020. I'm sorry, it might take me a minute. This is an extremely long case. It's like 81 pages. It's pretty good if you want to know how this works, then this is what you have to do. You have to read cases. That a Fourth Amendment claim the date was timely. Accrual of claim for deprivation of liberty without probable cause. It looks like they are holding that. However, defendants insist that count 3 is untimely because the entirety. It looks like they've essentially held that all his claims are timely. Essentially, that's what they held. That's what they held. Wilson does not dispute that the Illinois limitation. However, he presents conflicting positions as to whether state law malicious prosecution is subject to a 2-year yada yada yada. Be timely recording decline to dismiss count 3 of the statute of limitations. Okay, so essentially what they held, they appear to found all of his federal causes of actions timely. And it looks like might his state law clause, let me see, the timeliness of state law claims as stated above, the city defendant, I don't even know how to pronounce that, also moved to dismiss as untimely Wilson's state law claims for malicious prosecution, intentional infliction of emotional distress, and civil conspiracy. All state law claims are untimely. Defendants maintain all Wilson state law are subject to 1-year statute of limitations. Okay, blah, blah, blah. I get that. The court finds that pursuant to the tort immunity, each of Wilson's state law claims is subject to a 1-year statute of limitations. Okay, so that 9 times out of 10, they're going to be time barred if he didn't bring them in time. But I'll get what I'm saying. I can't really find what I'm looking for, and I don't want to spend too much time on this. But if you're trying to sue the police for, let's say, a fabrication of evidence claim, you're saying that they fabricated, they manufactured probable cause against you. You can't do that until the case is in the criminal trial is ruled in your favor, because a cause of action does not accrue until all of the elements in support of that cause of action have accrued. So what they're going to do is, if you do that, they're going to say your claim is Heck barred, something like that. They're going to say on the Heck v. Humphrey, you can't bring the claim, which is essentially what they talked about in this case. If you see right here, this word Heck, they're talking about Heck v. Humphrey. That's what they're talking about. And the Heck rule, that's what they're talking about. This is why you have to read cases. You have to read. I don't really know any other way to get this through y'all heads. You're gonna have to read. You can file only if it's a constitutional issue. What do you mean, Gary? Let's see. What gender we have? What gender? We have gender now in this country. I'm not sure what you mean by that. All right, but yeah, if y'all have any questions, man, go ahead, post your questions. I'll get to them when I can. Kind of all over the place. This is a long case, but it had to be decided. And they ruled in favor of the plaintiff. Damn, this is a long case. This is 81 pages, y'all. Crazy. He sued he sued a lot of people in this case, y'all. A whole lot. Let's see. Where do I go? Okay, I'm gonna close. Do I close this one? If y'all want any of these case citations, y'all let me know, and I'll post them for you in the chat section. Because I have a whole lot of them. All right, let me see if I can go on my YouTube channel and see if I have any questions on there, and I'll try to address the questions on there. Okay, community section. Oh, also, I forgot to tell y'all. I think I did, but I'm gonna do it again anyway. The Know Your Right, the Know Your Constitution, the Carl Miller video, it's in here. So you go on here, you go on my channel right here, you click right here, just click this link. 2 more links will pop up. If you click on this right here, the Know Your Constitution video, it will pop up. I did that because YouTube, for some reason, they say I'm reusing. Good evening, folks. I want to thank you. Sorry, they say that I'm reusing this content. So I had to do that to try to get my channel back monetized. So I didn't want to delete the video because this is a great video, and Carl Miller taught me a lot. So let me go back. There's another one on here. I think it's William Cooper's video, Behold the Pale Horse. So if you want to still listen to this, it's on here as well. This is a good audio book too by William Cooper. Also, if you need to contact me or consultations, whatever, go on here, and this is what you do. I don't know what you need. Just pick out whatever you need, pay the fee, and then I'll contact you as soon as I can. It should be within 48 hours or less. Let's go back. Let me see if I got any questions on here. I'm gonna just go through this, y'all. This right here is a review from one of my someone who attended Litigation Academy, and we were originally scheduled for, what was it, was it 16? Yeah, it was 16 sessions, but after maybe about the fourth session, they were like, it just, everything just started to become clear to them that they really started to understand everything, and they just decided not to go along with the additional 8 sessions. So we only got 8 sessions in, and he's feeling really good about it. So this is his review. So I just wanted to post that for y'all to see. I'm gonna go through this because I haven't been live in like 3 months, y'all, probably a little over 3 months. So I'm gonna try to see if I can answer some questions. The principles of equity are deemed to be part of the common law in this country. I let me see. Okay, I'm not sure who this is, but if you need assistance with your case, it's best to just, I would just schedule maybe like a 30-minute consultation or something like that. It's only $25. That's what I would do if you need help with your case. And we can just go from there. I'll let you know if I can help you or not. If I can't help you, I'm not even going to waste your time. Keep your money. If I can help you, but if you're not going to help yourself, I don't want your money. Keep your money, because you're going to have to study this. They're not going to let me come in there and argue this case for you, but I can teach you to the best of my abilities how to argue this case and what to expect from these people, because they just terrible. They're terrible. They are terrible. I got to start studying negotiable instruments more. When I get some time, I'm gonna spend a lot of time in that. Critical distinction between the common law crimes. Okay. I posted this a while back. I didn't really get any comments on it, but I posted this a while back for everybody to see. This is essentially it's like a what's this due process? It's like jurisprudence on due process. So if you interested in this, or you want to know what how do I word this? What due process rights were violated in your case? The only way you're going to know is you're going to have to read the cases to see. The cases are going to tell you what your rights are. And then once you realize what your rights are, that will allow you, in my opinion, to at least attempt to make a proper objection as to preserve that right being violated on the record. So you can take it up, take it up on appeal or something like that, or file a motion to vacate the judgment, something along those lines. This is let me show you how much it is. It's a lot. It is. That's why I didn't even post all of it, because it's so much. This is how thorough it is. Look at all these footnotes. This is what you got to do, man. If you don't like reading, you need to just hire you an attorney and just get you a plea deal or something, because this stuff is not for everybody. It's mentally exhausting. That's one reason why I charge for my time. This stuff will wear you out. Elements of due process, initiation of the prosecution. Look at all this stuff, man. This is what y'all need to go and study. Y'all need to be going studying this stuff, man. All right, let's see. The torture claim because people are using pronouns. Oh, okay, I see what you're talking about, Gary. Hi, how does the statute of limitations run out if you don't know you're in another case and another judgment has come against you? That there's a possibility, Miss G, that you can get that judgment vacated for lack of due process. They have to give you due process, and they can't just give you due process at one hearing and then violate all your damn due process rights at another hearing. It doesn't work like that. They have to give you due process throughout the entire prosecution of the case. So let me see. How does the statute of limitations run out if you don't know you're in another case? So it seems like they haven't perfected service of process against you. And in order for them to in order for the so-called court to properly exercise jurisdiction, they need subject matter jurisdiction, territorial jurisdiction, and I think in personam jurisdiction. But I mean, some people might say territorial jurisdiction and in personam jurisdiction are kind of alike. I tend to think that there's a distinction between the two. But let me show you what I'm talking about, Ms. G. So you are in a territory called the District of Columbia. Failure to perfect service of process. We're going to say judgment void for lack of due process. And what I'm going to show you is this is just a principle. I'm not going to go to the District of Columbia yet. I'm going to show you that this is a principle and it applies everywhere. Urban's argument presents the due process issue of whether debtor provided notice that was reasonably calculated to appraise Urban that its rights were in jeopardy. Lack of notice and sufficient service of process results in lack of due process, properly renders a judgment void. They have to serve you. So what's going on is they send out mail to your house. There is a presumption, that is only a presumption, that you actually received the mail. You have to come back and rebut that presumption by simply stating that you did not receive the mail. Maybe they didn't send it to the right address. Maybe they sent it to the wrong address. Maybe it got lost in the mail or something. Maybe they put it in the wrong mailbox. Maybe it fell on the ground and blew away. Anything could happen. You don't know. All you know is that you didn't get it. That's all you know. And since you didn't get it, generally speaking, they're supposed to vacate the judgment against you and give you a new hearing. Or if there was a trial had or you got a default judgment against you or something like that, they're supposed to vacate that judgment and It's like give you a trial de novo or something like that. Let me go here. I'm going to read a little of this for you. And this is February 6, 2016. Gotta find this right here. Okay. So here it is right here. As the Supreme Court of the United States has explained, an elementary and fundamental requirement of due process in any proceeding which is to be accorded finality is notice, reasonably calculated under all the circumstances to appraise interested parties of the pendency of the action and afford them an opportunity to present their objections. They have to do that. They will not do that. They will lie and violate your damn due process right. I'm telling y'all what I know. I'm dealing with a so-called judge now. This so-called judge, he always compliments me and tells me how intelligent and smart I am. And then as soon as I start to cross-examine their witness, he always cut me off. Always. He just gets belligerent with me and starts screaming for no damn reason. That man is intimidated by me. He is intimidated by me because there's no reason for you to be doing that. Then I have bailiffs in there surrounding me. It's like 2 bailiffs. They'll pull on me, pulling on my arm and shit. I can't even argue my case. They're trying to throw me off. They are intimidated by me. When they start doing shit like that to you, they are intimidated by you. They're trying to intimidate you because they are intimidated by you. That's what they're doing. They want to call you crazy and a sovereign citizen and all this man. Fuck out of here with that shit. Pardon my language, y'all. How long does a 7th Circuit have to respond to a petition for rehearing? Let me see. I don't know, man, because criminal cases take priority over civil cases. So if you have a civil case, it could be a while. You know, it could be a while. I don't know how long it's going to take, to be honest with you. Venue, subject matter, in personam jurisdiction are all needed to prosecute. Not necessarily venue, because they still can prosecute the case even in an improper venue. If you don't object to it, they still can prosecute it, but they can't do it in absence of subject matter jurisdiction. They can't do that because you can't waive subject matter jurisdiction. You can waive in personam jurisdiction. All right. Proper service is presumed. That's right, SG. It is presumed. The right to challenge in personam jurisdiction is presumed to be waived until challenged. That is correct. That is correct. If you weren't served properly, the court didn't even have personam jurisdiction. That is correct. If within the appeal time limit, the trial judge can void. Well, you can void it. You can void it whenever. A void judgment is a void judgment. Remember that case I showed y'all when this guy, he filed he was filing motions in there or whatever. But long story short, he was seeking to vacate, or in other words, void a judgment after 10 years. And they voided the judgment. They don't care if it was 10 years. If past it, the judge no longer has jurisdiction. Let me see. And you have to go to a superior judge. Let's see. Never served me anything but added me with the other man. Well, they never served you anything. You can motion to vacate that. I'm telling you that right now. That's void. That is patently void. They probably didn't even attempt to serve you anything. That is void. I'm telling you that now. Now, let me go to the District of Columbia because I'm going to assume that that's where you are. Let me read a few more of these other cases first. So this is in Indiana. A judgment entered where there has been insufficient service of process is void for want of personal jurisdiction. A judgment entered, well, that's Indiana, Banker, Illinois. A judgment entered where the requirements of service of process. Let me see. A judgment is void where the requirements of service of process are not satisfied. They got to give you due process, man. That's it. To be honest with y'all, that's equity. That's what they're doing. That's equity. Let's see. Tennessee, service of process, which does not meet the requirements of the rule, is void, and a judgment based on void service of process is void. Let me show y'all. Something along those lines. Where the plaintiff complies with the rules governing service of process, a rebuttable presumption exists that service was perfected. So they're saying there's a rebuttable presumption. So they're saying there's a presumption that is rebuttable that exists that service was perfected. That's what's going on. They're presuming you got it. They don't give a damn if you didn't get it. They're going to presume that you got it until you come in and object and say you didn't get it. Everything is a presumption. Matter of fact, let me show y'all something. Let me show y'all something else. Trial court proceedings are presumed correct. Let me see if I can get this down. So anything that happens in the trial court, like let's say when you go to court and you challenging jurisdiction and you're asking questions, what they'll do is when you do that, they will construe it as you pleading not guilty, and they will enter a plea of not guilty for you. You have to come back and rebut that presumption. You have to come back, file an affidavit, and say, "Look, I made a special appearance to this so-called court, and to know the nature of this accusation against me, and to know the the nature, basically all the due process." I don't want to get into all that right now because it's kind of a lot, and I don't really want to confuse nobody. But so what they'll do is they'll enter a plea for you of not guilty. You have to rebut that presumption that you entered a plea of not guilty. How do you do that? You do that with an affidavit. In the absence of a record, trial court proceedings are presumed correct. There's a presumption that they did everything correct. You have to rebut that presumption. Trial court judgments are presumed correct. We reverse a judgment only if there has been a miscarriage of justice. See this right here? Certified records of trial court proceedings are presumed to be correct, but that presumption can be rebutted. Let me go and read y'all this just to give y'all some let me see if it's gonna say it. To overcome the presumption of accuracy and to be entitled to relief, a party must satisfy the following requirements. 1, seasonably seek relief, assert with specificity the alleged. Okay, now this is in Michigan, all right. But I'm trying to get y'all to understand this, man. Everything is just a presumption. Damn near every damn thing. I can't find that one. Let me see if I can find another one because I can't get that one. Let me copy and paste it. You better object. You must object when they do shit like this, and they will do it. Right here. Here's another. I might be able to do this one. A reviewing court is bound by the certified record of proceedings in the trial court, and the record is presumed to be correct unless it can be shown to be otherwise. You got to rebut that presumption. That's why I'm telling you, file a motion to vacate, and in support of your motion to vacate, you need to file an affidavit and attach your affidavit as an exhibit to the motion to vacate. Now, if you don't know how to do that, I strongly advise you, ma'am, to I'm not sure what your budget is, but whatever it is, just send me whatever you can afford, and I'll see if I can help you with your case. If that is what happened, then you should be able to get that vacated, provided that they do what the fuck they supposed to do. Because to be honest with y'all, you're not supposed to do this. You're not supposed to know this. You're not supposed to be right, and you're not supposed to win. Now, there are some people that are watching this video right now who I am actively helping litigate cases. And some of these people can see what I'm saying for themselves. They can see it for themselves because they can understand it. When you know what you are doing, that is when they will blatantly, knowingly, and intentionally violate your due process rights. They don't give a damn at that point. When you're wrong, they will be more than happy to tell you you're wrong. But when you're right, they're going to tell your ass you're wrong. They might not, and they're not going to give you any explanation for it either. They're going to give you some, they're just going to make up some shit. It don't have nothing to do with your case. They'll misconstrue the evidence. They'll omit evidence. They will ignore you. They'll just, man, I don't even know where to start. But none of this stuff surprises me what they do. It really doesn't surprise me. I can't find, let me see. That's Illinois. Okay, Virginia, right here. A transcript of the testimony and other incidents of a trial certified by the trial judge is presumed to be correct and, in the absence of proof to the contrary, is binding on this court. Yada, yada, yada. All right, let me... All right, now you're in the District of Columbia, so let's go here. Should be in the... Is it in the E? Right here. So it's going to be right here. So let's see right here. Let's see what they're saying. It is unimportant whether the docket entries showing service of process are considered to have made out a prima facie case of such service, or whether they are deemed to have given rise to a presumption that service was made. Let me see. The presumption of service arising from the recital and transit, blah, blah, blah. I'm trying to find something that's just less confusing for you. All right, so let me see. I think I'm going to try to read this. You see where it says, such service is effective even if the defendant does not actually receive the summons and the complaint. So let me go and read this. Let me see if I can hopefully get you to understand something. So where we go? I'm going to say summons. All right. Trying to find it. Let's see. I'm gonna read some of this. All right. Here it is right here. This is a perfect example right here. Is this a federal case? It looked like a federal case. Well, I mean, it's in the District of Columbia, so obviously the rules are going to apply. Yeah, this is it right here. Michelle A. Jones appeals from the denial of her Rule 60B for a motion to vacate a default judgment. So this is very similar to your case. The judgment was entered against her in an action for possession of real estate brought by her landlord, appealee Carl Hirsch. Jones contends that the judgment was void for two reasons. First, Jones argues that the court never acquired personal jurisdiction over her because she was not served properly with the summons and complaint. Alternatively, Jones argues that the court acted without authority because it entered the judgment without requiring ex parte proof, even though she had appeared in court and even though she had appeared in court on the return date and answered the calendar call. What the hell you make a general appearance down there for? I mean, I don't know. Like the motions judge, we reject Jones' first argument. We hold that valid service on Jones was achieved when the process server went to her residence, the property sought to be recovered, found that Jones was not there, and delivered the summons and the complaint instead to somebody else above the age of 16 years. And I can't even, I'm stumbling over my words, y'all. Hold on. Instead of somebody else above the age of 16 years who was residing at or in possession of the premises. No additional efforts to find and serve Jones personally were required for such substitute service to be effective. Let me see. Hirsch filed a complaint against Jones for possession of real estate. Let me go down to the law. But this is a case you probably need to read. Three weeks later, Jones moved pursuant to Civil Rule 60B4 to vacate default judgment. Let me see. I think it looks like it's going to be right here. Decision whether to relieve a party from a final judgment pursuant to Rule 60B is committed in most instances to the sound discretion of the trial court, and appellate review is differential and limited. But the trial court has no discretion when relief is sought pursuant to subdivision 4 of Rule 60B on the ground that the judgment is void. Whether a judgment is void is a question of law, though like all legal questions, it may depend on the court's resolution of issues of facts. So that what they're saying is the facts are going to determine if this judgment was void as a matter of law. And if a judgment is void, it must be vacated. The movement need show no meritorious claim or defense or other equities. That's an equity rule, y'all, to vacate that judgment on his behalf. He is entitled to have the judgment treated for what it is, a legal nullity. A showing of a meritorious defense is not required when a judgment is void. Further, Rule 60B places no time limit on an attack upon a void judgment, nor can such a judgment acquire validity because of lashes on the part of him who applies for relief from it. These are the cases right here in support of that contention. Thus, appellate review of the court's decision on Rule 60B4 motion is not differential. It is de novo. Let me see. Regrettably, we have not always been clear about these principles. There are occasional statements in our opinion suggesting that the court may have. I'm going to send you this case to read, because I'm not going to read all of it. Let's see. I'm going to read. I think I'm going to read the section right here and probably a little bit more, and that's probably it. Regrettably, we have not always been clear about these principles. There are occasional statements in our opinion, suggesting that the court may have a measure of discretion in ruling on a Rule 64B motion. Notably, in Jones, we reverted to standards applicable to motions under other subdivisions of Rule 60B, stating that in determining whether to grant relief under Rule 60B4, the trial court must consider whether the movement received actual notice of the proceedings, acted in good faith, and acted promptly upon the discovery of the judgment. All right, that is equity. The court must also consider whether prejudice to the non-moving party would result, adding that our standard of review is for abuse of discretion and holding that the trial court abused its discretion in denying relief. Same, but upholding the trial court's denial of a Rule 60B4 motion because the movements failed to sustain their burden of proving that the challenged judgments were void. Recently recited Jones for the same proposition. Let me see, blah, blah, blah. But we must disavow such statements as erroneous dicta. In actuality, we never have upheld as an appropriate exercise of discretion a trial court's refusal to vacate a judgment that was void. If a judgment is void, the only way that the court may exercise its discretion is by granting relief. They're saying whenever a judgment is void, the only thing that the so-called court can do is grant the relief, vacate the judgment. They're saying that is the only thing that they can do. The concept of void judgments is narrowly construed. A judgment must be void, not merely voidable. In other words, that it can be made void. It has to be void. A judgment is not void merely because it is erroneous. Rather, for a judgment to be void under Rule 60B4, it must be determined that the rendering court was powerless to enter it. Typically, therefore, a judgment may be held void only if the court that entered it had no jurisdiction over the parties or the subject matter, or if the court's action was otherwise so arbitrary as to violate due process. That is a principle. That's a principle. All right, so if they violate due process while they're issuing a judgment, that order is void. If they don't have subject matter jurisdiction, they try to enter a judgment, that judgment is void. If they don't have in personam jurisdiction, they try to enter a judgment, it is void. All right, so this might be applicable to your case. Let me go ahead and see what the questions are. Let's see. I was talking about who has to void it, not whether it was void. Okay. After the appeal period process, an inferior court judge no longer has the jurisdiction to void order per am jurors. Well, yes, they do. They can still, even if they like if you appeal a case, SG, if you appeal a case and you probably you would have to seek leave of court. In some places, you would have to seek leave of court to file a motion to vacate in the trial court to vacate the judgment for lack of either subject matter jurisdiction, in personam jurisdiction, or territorial jurisdiction. If the appellate court grants you leave to file that motion in the trial court can vacate its own judgment. They still have jurisdiction to do that. Jurisdiction. Hit the like button, everybody. Only pro se litigant that gives you golden nuggets. Right? I appreciate that, man. I really do. Because I do my best. I really appreciate that. Just for your information, because I've wasted a year waiting on a continued motion to void I filed in district court. They continued it and never set a date instead of dismissing for lack of jurisdiction. Yeah, they'll do that. You have to be under oath or affirmation to commit perjury, and neither the judge nor the prosecutor. That is correct. I agree with that. Oath of office binds them to uphold the Constitution and to protect it. I agree with that. Man, it's like they doing something else, man. I'm still trying to figure it out because you're in a territory, and since you're in a territory, the legislature is sovereign over the territories because they created it. It's their dependent. That's why they have to take care of it. That's why they're always receiving public funding over there. SG is let me see, is lying necessarily unconstitutional? Though I would say yeah, because a police officer cannot under oath fabricate probable cause and then use that probable cause to arrest you, and then take that affidavit that he swore under oath with the fabricated evidence to a judge, and then a judge uses that same fabricated evidence as a basis for issuing a warrant for your arrest or the seizure of your property. Yeah, that's unlawful. You can't do that. You cannot do that. Hell no, you can't do that. You cannot manufacture probable cause and then use that manufactured probable cause as a basis to arrest anybody for probable cause, or as a basis to determine that probable cause exists for a damn trial. You can't do that. No, you can't do that. Want me to tell you why you can't do that? Let me see if it's still up here. Because no one can take advantage of his own wrong. Hell no, you can't do that. You violated equity when you do that. No, you can't do that. My opinion is that all criminal case judgments are void judgments when there's no victim. I think I mean, well, I'm gonna say I disagree with that, because you're not in a they're not operating on a common law jurisdiction. You're in a territory, and so over there, fictions are the victims, and a fiction can be a victim because corporations have to enforce their own rights. You know, that's why when you ride down the street and you run a stop sign or something like that, and the police gets behind you and they give you a traffic citation, they're filing a lawsuit against you. They're enforcing their right, their so-called rights. They have to sue you. That's what they're doing. Corporations have to enforce their own rights. That's why they have attorneys to represent them, because their corporation, the public defender, even though they work for the corporation or whatever. Now if this was a common law case and they were operating on the common law jurisdiction, I would agree with you on that. But they're not operating on the common law jurisdiction. Duty of proof is on you if you state the person that was served your summons was not of proper mental capacity to receive the document. If the statute doesn't require a minimum age, if they don't have the mental capacity, or let me see. Hold on. There may be a case law or there may be a statute that tells them when the service is perfected. So, but I do agree with you, SG, because they do have to have the proper mental capacity to receive the document in the first place. So I agree with you on that. So let's say they serve somebody, the statute requires or the case law requires that they be 16 years old, but they serve somebody that is 14 years old or 15 years old. Then as a matter of law, you can come back and argue that and say you were never served, because the facts clearly show that you served this on someone who does not qualify to perfect service of process on you, if that makes sense. Let me see. They can't prove you didn't get it, but they will claim you are a client. That's why child support doesn't send out certification of letters. So I always claim you never got it and never say you. I kind of agree with that. I was pointing out that not all lies violate the Constitution. Damn, boy. I agree with that, SG. That's why you got to get them under oath. I know some can. Let me see. So a crafty lawyer or judge can lie without violating their constitutional oath. That was the point. All right. When they do that, SG, what you should do is you should object and say, Your Honor, that evidence lacks foundation. Either it lacks foundation or it's assuming facts, not an evidence. because what the judge is essentially doing is they're exercising discretion by saying something is true that is not true, when their discretion is limited to the rules of evidence. Their discretion is limited to what has been properly admitted into the rules of evidence, unless you then object. That's why you have to object to it. It's a presumption, man. All of it is a damn presumption. Let me show y'all something. Let me read this a little bit more, and then I'm gonna show y'all something. I got to get off here soon. I'm only planning on doing 2 hours. All right. Right here. A default judgment entered in the absence of effective service of process is void, even though the defendant has actual notice of the action. This is so because without proper service, the court has no personal jurisdiction, and the court thus lacks power to act unless the defendant has waived service. Since service of process is the means by which a court asserts jurisdiction to adjudicate the rights of the party, it is uniformly held that a judgment is void where the requirements for effective service of process have not been satisfied. If Jones was not served in accordance with the law, it is immaterial that she actually did receive the summons and the complaint that the process server left for her. Our cases establish that faulty service of process cannot be cured merely by actual receipt of summons and complaint. Service of process in a landlord's action to recover possession of real property is governed by DC Code Section 16-1502. So let me go. All right. And I'm going to read this right here. I'm going to read this footnote right here. Number 6 right here. Due process requires that notice be reasonably calculated under all the circumstances to appraise the interested parties of the pendency of the action and afford him an opportunity to present their objections. It is beyond dispute that this requirement is satisfied when service on an individual is accomplished as it effectively was in this case, and the Superior Court Civil Rule 4E2 and its federal counterpart authorizes without restriction for civil actions in general by leaving copies thereof at the individual's dwelling or usual place of abode with some person of suitable age and discretion then residing therein. Noting, among other things, that the plaintiff is free to employ this method of service regardless of whether the defendant can be served personally. Such service is effective even if the defendant does not actually receive the summons and complaint. I'm gonna post this case in the chat for you, ma'am. You need to read this case. If you don't know what you're doing or if you need help, I'm not sure what your budget is. I know you're going through something over there. Last time we talked, even though it's been a while since we talked, but if you need help, I think I have some time to help you. I think I do. Let me see. Yeah, try your best to always have a court report if you can. If you don't object, it becomes a fact. Yeah, you got to object, or they gonna presume it's true. It's all of that, man. It's all smoke and mirrors, man. It's all smoke and mirrors. All smoke and mirrors. Why are some saying to not operate on the record? My intuition says always on the record. Yes, thanks. When you say why are some saying not to operate on the record, what do you mean, Ms. Norris? What do you mean when you say that? Channel. I'm not sure what that is. I was trying to look at your comment, but it looks like YouTube hid your comment. I don't know why. But what do you mean? You're welcome, Levant. You're welcome. Oh, Miss Norris, if you, I kind of forgot about it. If you still want to do Litigation Academy, you need to get at me as soon as you can, ma'am, because I'm trying to make my schedule, and I don't think I added you to the schedule. A lady I follow says keep private. It depends on what she means by keep private. So if I had a call-in number, you can call in. Operate off the record. Operate off the record. I'm not sure what they. No, when you're in the public, when you're in an administrative hearing, because it's all administrative. When you're in there, you want to be on the record because you have to keep these people honest, because everything that they are doing is a presumption. It's all presumed to be true. It's presumed that they acted correctly. You have to rebut that presumption. And the only way, in my opinion, that you can effectively do that is if there's a stenographic record with a court reporter in there recording everything that happened. That's why when they start lying, when you make a special appearance to challenge jurisdiction or something like that, and they enter a plea of not guilty for you, that's why you need to file an affidavit stating what actually happened, because they will do that. That sounds like they're saying do administrative process, stay out of the public controversy. There was something I wanted to show you. I forgot what the hell it was. Completely forgot what it was, y'all. I think it was to a question up here somewhere. It was a question down here, and I forgot what it was. Let me see. That was the point. You can lie without violating their oath of office. Come into play. If you don't object, it becomes true. Operate off the record. Yeah, it was something else I was saying, Ms. Norris. Right. Okay. Thanks for clarification. Yeah, man, look, if you can, hire your own court reporter. The court reporters will lie on your ass too. I'm telling you what I know. I've seen it. They will misrepresent what happened on the record. They will do that. If that so-called judge tell their ass to do that, they're gonna do it. Not all of them, but some of them will do it. I've had it happen to me before. I was in an administrative hearing, and this so-called judge clearly states that he does not have subject matter jurisdiction on the record with a damn court reporter in there. And when I filed an appeal on the case, that admission that he didn't have subject matter jurisdiction was nowhere in there. And I know for a fact I heard him say that, because that was the reason why I challenged it. You don't have the subject matter jurisdiction. It's just smoke and mirrors. You're just acting. That's what they do, man. Man, if y'all are new to this, y'all in for a rude awakening. A very rude awakening. This stuff is going to piss you off once you realize what's going on. It was what was it that I wanted to show y'all? I've been on here for 2 hours. Now I'm gonna get off in like probably 10 minutes, y'all. So if you have any questions, go ahead and ask your questions. I'm not gonna be on here much longer. What was it? Damn it, I forgot what it was. It was somebody had told me. I forgot what it was. Damn, I forgot what it was. Also, I'm gonna put this in the chat. Y'all need to go and study this. If you want to know what your rights are, you are not going to know what your rights are until you study. The only way you're going to learn, you're going to have to read cases. The only way I learned, I had to read. So let me put this in the chat for y'all. Be careful with it. That's a good idea, Miss Norris, but be careful because they will seize your recording device. They'll steal it. I told the judge that the court lacked jurisdiction and the judge agreed but still proceeded. Look at this shit. Boy. I'm not surprised by that at all, man. I'm not surprised by that at all. Let me show y'all what I'm talking about. This is what's going on, y'all. Let me take this out. I've talked about this quite a few times on my channel. I got to get y'all to, I guess I got to get some people to see this. Okay. This is a principle, all right? You are not in a court. You are in an administrative agency that they are calling a court. And what they are doing is they are trying to mimic courts of general jurisdiction. That's what they're trying to do. All right. So right here it says, however, as to courts of inferior, aka administrative agencies, or limited jurisdiction, jurisdictional facts must affirmatively appear on the face of the record. When you challenge jurisdiction in any administrative agency, they have to prove it on the record of the administrative proceedings. And they are not entitled to the presumption that they have jurisdiction because their jurisdiction is extremely limited. It's not a court of general jurisdiction. Courts of general jurisdiction, aka common law courts, because they were created under the common law, they were created by the Constitution. Their jurisdiction is extremely broad. They can act with statutes or without statutes. They don't need statutes at all. They are entitled to the presumption that they have jurisdiction because their jurisdiction is extremely broad. Inferior courts cannot ignore the lack of jurisdiction. Nobody can. If a superior court can't do it, you know a damn inferior court can't do it. In courts of limited jurisdiction, though not inferior, the facts which are requisite to the jurisdiction must appear on the face of the record. It is held that justices of the peace are of limited and inferior jurisdiction, and there is ordinarily no intendment in their favor, and their jurisdiction must appear on the face of the proceedings, especially so where the property involved fixes the jurisdiction. Let's see what else we got. Now, I disagree with this because the U.S. District Court is a court of limited jurisdiction. So I disagree with that, even though this is from 1853. But they might be leaving something out. When it says the District Court of the United States, this is an old case too, by the way, is not an inferior court of limited jurisdiction in the sense that renders it necessary to show its jurisdiction on the face of the records. I disagree with that because when you filed in a 42 Section 1983 lawsuit, you're using a statute. All right. The legislature only creates administrative courts. So the rule requires that you plead the jurisdictional, the subject matter jurisdiction, invoking the U.S. District Court's jurisdiction. It's right there in the rules. The general superintending power of this court over the proceedings of inferior tribunals, especially of such as are created by statute, and possesses special powers only, and exercises a limited jurisdiction, is unquestionable. That's the Rhode Island Supreme Court. I did a video showing y'all what they doing, man. I did so many videos on this showing y'all what they doing. Let me see if we got any more questions. There's a comment down here. I'm not sure what it is. I can't even see the damn comment. I don't know what the comment is. I'm not sure what the comment is. It won't let me see it. Let me try to do. Okay, there we go. Okay. Thank you. I'll get set up with Zelle. Thanks. Thank you. I motion for permission first. Yeah, try to do that. Try to do well. Where you are in you're in Oregon, I think. What's the name of the court you're in? Because they may already have a court reporter in there. I don't really know, but if you're already dealing with them, if you said you're gonna bring your own, well, you know what? Just bring your own, because even if they have a court reporter in there, they're not gonna go on the record unless the so-called judge tells them to go on the record. And they typically like to use that to their advantage. At least that's what one judge did in my case. He likes to use that in his advantage. Miss G, you should I think you still have my number. Either shoot me a text or call me. And well, let me see. We all right, Miss G, I'm still doing the $25 hour video Zoom recording meeting. I'm still doing that. So when you get time, send me $27 to Zoom. I mean, $27 to my Cash App. I'm sorry. Let me put my Cash App in here. Send me $27 to there. The 27. I mean, the extra $2 is to cover the transaction fee. But send me $27 there. And put your phone number in there, and I'll call you. And we'll do a Zoom meeting, and I'll see if I can help you. Hopefully, I'll see if I can help you. Let me see. Holly says I'll get set up with Zelle. Thanks. Talk to you soon. Okay, thanks. Yeah, when you can. I kind of forgot. I think I already said that, but I kind of forgot. When you can, Miss Norris, just do that as soon as possible, so I can go ahead and put you on the schedule. Because if not, I'll forget. So I don't want to forget. So just do that, and I'll get to you. You can proceed voluntarily. I assume. Let me see. Some cases you didn't object to proceeding anyway, so they assume you were proceeding voluntarily. I assume. I agree with that. SG. Quasi. Yeah, quasi. That's what they do. I read that because it's maritime law, you don't cross galley to maintain status. Discuss to resolve from outside the area where jurisdiction is presumed. Justice and circuit, exactly. I mean, to be honest with you, your pleadings should be enough to let them know, you know what's going on, and that and that you're no longer the legal entity, because it's really it's a surety, it's a dependent, it's a legal person, it's a juristic person. It's something that they created in their territories. It's their subject. So I think I sent you a document when we did that Zoom, Miss Norris. I sent you a document that I had drafted for somebody, but it's just I don't really want to make it public yet. But I sent you a document. If you go over and read that document carefully, you'll see exactly what I'm talking about, because you're drawing a distinction between you and the legal entity. Yeah, SG is right on that. Now, you can make an appearance on a piece of paper. You don't have to go to court to make an appearance. You can make an appearance on a piece of damn paper. That's how you know all this shit is a game. It's all a game, man. I lost a lot, but I know who has my documents. I worked on all last winter. I need to share with you. Okay, let me see how many people am I helping right now? I got time. I'm helping one. I think I'm helping like 3 people right now. I finished one case, and so we have a little time on that. So I should be able to help you. I should be able to help you. I don't know what your budget is, okay? And I'll just do the best I can, ma'am. I'll do the best I can to help you. But based on what you're saying, it sounds like that judgment, there's a strong possibility that judgment could be void. Let me see. No postman can agree you got a letter from any court because they only look and the address not the same. I can agree with that. Okay. All right, y'all, I'm gonna get off here. I'm starting to get a damn headache now. And I'm getting hungry. I gotta get me something to eat. Okay. All right. So before I leave, any more questions? Post office rule. Man, this is what they calling it, SG. And this is why I'm still trying to figure it out. Maybe I got to go and read some older cases or something. Is it going to be, I think it's going to be up here because I was posting about it on my YouTube channel not too long ago. Right here. This is one of them right here. Was that Conal O.R. McGuire, a member of the American Bar Association, Special Committee on Administrative Law, in an article published in 26 Georgetown Law Journal, says administrative law is a separate and distinct branch of the law. It is not common law, equity, or admiralty. This court has recognized the principle with respect to the Industrial Insurance Act that controversies arising under it are controlled by special statutory proceedings exercised in derogation of or not according to the course of common law. So they're saying it's not common law, it's not equity, and it's not admiralty. But they don't say it's not maritime, so maybe it's maritime. But either way it goes, we know that it's not common law or equity, so we can rule that out. Yeah, if you want to cash out the payment, Miss Norris, you can. But the reason why I was trying to get you to do it via Zelle is because it's cheaper. Cash App charges a fee. I don't know how much the fee is. So, all right. So if you like for six classes in Litigation Academy, it's $300. Okay, but if you pay via Zelle, you save $50 because Zelle doesn't charge you a transaction fee. And I do that just to try to save people money. You know what I'm saying? Because I know some people they just can't afford this, even though I don't think that I'm expensive. But some people they just can't afford it. So if you want to, you can, but you're probably gonna have to send instead of $250, you would probably have to send maybe like $330 or $40 or something like that, because they're gonna take out they're probably gonna take out maybe $15 or $20 in a transaction fee or something like that. It's probably gonna be more. To be honest with you, I don't know. I don't know how much it is. So that's why I always tell people to just do it via Zelle, but you can use other methods if you want to. Got to read their book on admiralty. Yusuf recommends. It's codified in the statutes. Statutes are part of admiralty. So is insurance. I agree with that. I have read what you just referenced again. Or I have to read what you just referenced again. All right, y'all. Let me get off here. Getting a headache. And I'm hungry. So hopefully I was able to help somebody. You know. I'm gonna post my Cash App again, Miss Norris. Because I'm not sure if you saw it. Everybody enjoy your evening. And I'll try to do another live soon. I don't know when, but I'll try to do one soon. Everybody enjoy your day. Supreme